The state offers exhibits by stipulation.
Okay.
The state offers DD video 1, DD video 2.
Okay, 1 second. DD video 1, DD video 2. There's a written stipulation, right?
Yes, Your Honor.
Let me just find the right one. I have a whole bunch of them up here on my bench, but I can't find that one. Let me see, I might. I don't have that stipulation. I don't know if it was tendered to the court previously, but I can't find that one.
Can I have a moment, Your Honor?
Yes?
Thank you.
And I can make a copy if we need to. Wait, let me just. I don't have it.
May I correct, Your Honor?
Yes. Yes, you may.
I'm showing you page 10 of a stipulation that was between People of the State versus Thomas Gaffney. The same stipulation was made, a written stipulation, as to these exhibits between Joseph Walsh and David March's counsel.
Okay. Thank you. All right, you may proceed.
The state offers DD video 1, a surveillance video from Dunkin' Donuts. The state offers DD video 2, a surveillance video from Dunkin' Donuts. The state offers FP video 1, a surveillance video from Focal Point. The state offers FP video 2, a surveillance video from Focal Point. And the state offers split video 1, split video 2. Split video 1 was previously entered into evidence. Split video 2 is a split video of the Dunkin' Donuts video and dashcam 813R. State offers those exhibits at this time by stipulation.
Okay, regarding all defendants?
Regarding all defendants, Your Honor.
Okay. Any objection or so stipulated, Mr. McKay?
But to the videos, no, and we stipulate to the foundation.
Okay, Mr. Pugh
Same, Your Honor.
and Mr. Fahey.
Judge, no objection.
Okay, so People's exhibits, Dunkin' Donuts video 1, Dunkin' Donuts video 2, FP video 1, FP video 2, and split video 2. The identification marks are stricken and they will be admitted.
May I have a moment, Your Honor?
Certainly, take your time.
The state has binders as to the stipulated exhibits that were admitted, including the electronic media, for all counsel in the court, if I may provide a copy.
Okay, any objection? Mr. McKay?
No.
Mr. Pugh?
No, Your Honor.
Mr. Fahey?
No, Your Honor.
All right. And that's for the court?
For the court and all parties of the stipulated exhibit.
Thank you.
Could I just ask counsel, Your Honor, which of the videos that have been admitted into evidence by way of stipulation have been published in court? Sure, no.
Mr. Watson, I know 813R and the focal point, there were 2 focal point videos that I can recall right off the top of my head.
Both parties have published 813R.
813R.
Dash cam 1.
Right.
Yes, Your Honor. Both parties have used that to cross-examine and
Right.
publish.
But I thought the focal point video was with Officer McGilligan as well. That was the focal point.
Your Honor, it was the Chicago
Greater Food Depository, that's it.
1 and 2.
Right, Chicago Great. So those are the only ones that I remember being published
By all parties, that's
by
right.
all parties, right? Does that answer your question?
Yes,
Sabrina?
the Dunkin' Donuts were not published so far.
Correct.
Thank you.
Your Honor, may I approach?
Yes. Thank you. Okay, Mr. Watson.
The state offers Snelling TR1 as an exhibit of the Snelling TR that was marked on into evidence during his testimony.
Was that the big blow up?
Right, we want to mark it and admit that.
Okay, what do you want to mark it as?
We want to mark it, Your Honor, as Snelling TRR1.
Okay. Any objections to that being admitted? Mr. Kay?
No.
Mr. Fahey? Oh, I went out of order. Mr. Pugh?
Yeah.
Mr. Fahey?
Judge, relevance as to Officer Gaffney, because he was marking this in response to the incident that happened on Pulaski Avenue. So it's really not relevant to Officer Gaffney.
All right, Mr. Watson, any response to that? I don't need a response.
Okay.
Your objection's noted. I'm going to admit it, so the identification marks are stricken. It will be admitted. If it's not relevant to Mr. Gaffney, this court is perfectly capable of not considering it against Mr. Gaffney.
Thank you, Judge.
I will only consider evidence that's relevant for him.
May I approach, Your Honor?
Yes?
He labeled it as tab 10 to place behind tab 9 of Sergeant Snelling marked exhibits during his testimony.
Thank you. Okay.
I would note that, of course, the binder that we placed up, tab 18, is the electronic media.
I saw that. Thank you. Tab 18 is the Welsh PR guide. I think 19 is the electronic media. Looks like it's a traffic drive.
Thanks, Your Honor.
Okay,
May I have a moment?
certainly. Take your time.
May I inquire of the court,
Yes.
are you in possession of the exhibit marked Walsh TRR5 and Walsh OBR5?
Judge, it would have been in the last binder that you received.
Okay, right, well, I was gonna let Mr. Watson finish.
Okay.
And then I have a number of stipulations that are file stamped today that haven't been addressed. So I was just gonna let Mr. Watson finish and then address these additional stipulations, which some are signed and some are not. So we have to address that as well. Mr. Watson.
Yeah, Your Honor.
Yes, of course.
Mr. Safer is going to address those stipulations and those exhibits that are marked behind the tabs that Mr. Q just raised.
Great, thank you. Are you ready, Mr. Safer?
I am, Your Honor.
All right, and you may proceed.
Your Honor, this involves People's Exhibit Walsh TRR 5, People's Exhibit Walsh OBR 5, People's Exhibit Gaffney TRR 2, People's Exhibit
Gaffney TRR 2,
yes,
okay, and Gaffney,
OBR 2.
all right, I'm ready.
And well, with regard to, and these would be offered only with regard to the Gaffney exhibits would be only offered as to Mr. Gaffney. The Walsh exhibit offered only as to Mr. Walsh.
Okay.
And there are stipulations regarding the authentication and foundation of exhibits, but not a stipulation regarding the relevance of the exhibit. And again, without belaboring it, of course, Your Honor.
1 second. So regarding not the relevance, but regarding the foundation, there's a stipulation for Mr. Gaffney regarding TRR2 and OBR2. Is that correct? So stipulated, Mr. Fahey?
Judge, we're stipulating to the foundation.
Just the foundation.
Yes.
Okay. Same for you, Mr. Pugh or Mr. Green regarding Mr. Walsh?
That is correct, Your Honor.
Okay, so these need to be signed.
I signed, Your Honor.
I have one that's not signed by Mr. Fahey or Ms. Brown Holmes, and I have the one for Mr. Walsh that's only signed by Mr. Green or Mr. Pugh or Mr. Stanley. I can't read the signature, but it is signed and not by Ms. Brown Holmes. So if you want to put the signatures on that, and then that stipulation will be received and admitted.
Thank you.
Regarding foundation, you can make your arguments in a moment regarding developments.
Thank you.
Thank you, Mr. Safer.
Thank you.
Okay. So it's the defense objection. You're objecting to the relevance. So I'll start with Mr. Walsh's objection first.
Your Honor, if I may.
Yes.
State placed us on notice as of yesterday that they intended to try to admit into evidence two documents, that being to the OBR and the TRR, that are related to an incident that occurred on October 3rd of 2015, which would be roughly a year after the incident that we're on trial for. In doing so, I expect that they are offering these two documents to show that the tactical response report has an allegation of assault, imminent threat of battery therein, and that the TRR report does not have a box checked for assailant, battery. Which, in concerning this, the problem with these two documents is that the court has no information regarding this incident at all. The one that's alleged here on October 3rd, 2015, unlike, of course, the October 20th, 2014, where we've heard all the facts and circumstances surrounding the incident. This does not include any testimony regarding this incident from any of the participants in it. What we would do by admitting this is begin a new mini trial about an incident, an officer use of force incident that occurred a year after the incident that we were on trial with. It's not relevant, first of all. Second of all, it's inadmissible because if anything, if it is the state's position that I guess that this TRR may possibly have been filled out correctly, it really becomes in a lot of ways a subsequent remedial measure, which is a matter of law are not admissible in trials. And it comes at a time after the incident that we are charged with in this case. And perhaps most importantly, if the state is allowed to admit this, the defense will be in a position to then have to go and request all of the police reports regarding this incident, the detective stops, the OCIRs, and we'll go through and call all the witnesses regarding this incident and to why the TRR might have been filled out differently a year later than it was back in 2014. And we're going to begin a mini trial on this incident here. All I have is, and all you have, if you have an opportunity to take a look at these, is a TRR and an OBR that tells you really nothing about the incident at all, save one line where it says, offender stated he did not mean to point the gun at the officers. I don't know what that means. I don't know the context of that. We don't have any of the reports regarding this. And of course, if we were going to allow this in for, because somebody felt that it was relevant to anything in regards to this trial, we would have to open it up to have all of the reports associated under RD number HY448683 and potentially investigate and call the witnesses in regards to this. And again, we got notice of this yesterday. So for that reason, Judge, will be moving to object to this issue.
Thank you. Mr. Fahey?
Judge, with regards to what has been marked as Gaffney OBR2 and Gaffney TRR2, the only thing I know about this incident is what was handed to me yesterday by the prosecution. I don't have the police reports. I don't know what this incident involved. The only thing I know is that my client apparently filled out an OBR and a TRR back on January 4th of 2007, about 7 years prior to this incident, Judge. These aren't police reports. Police reports are not admissible in court, Judge, under the rules of evidence. In addition to the relevancy argument that Mr. G just made, Judge, I don't know what this is about, and I certainly have no idea why the state would offer this or offer this into evidence right before they rest and give notice of it 1 day prior to that. Judge, for all the reasons that Mr. Q articulated, and for what I just mentioned, Judge, with regard to these police reports being hearsay, we're objecting to their admission.
Thank you. Mr. Safer?
Your Honor, these exhibits are directly in response to the cross-examination of Sergeant Snelling with regard to TRR reports and OBR reports, and the cross-examination of whether or not they are confusing or how boxes are supposed to be checked. It is in response to that that we would offer these exhibits for this state of mind of these individual defendants and against only their defendants. To say that they know nothing about these incidents is remarkable in that these reports are supposed to and do describe exactly what was happening in these incidents. As you heard the testimony of Sergeant Snelling, the TRRs describe what the subject's actions were and the member's response, why they responded as they did. The OBRs respond or describe the battery and or the assault on the officers and the circumstances of it. So these are statements, party admissions, by these individual officers regarding these incidents, and it tells you all about the incident. Mr. Gaffney's incident tells you that it tells you the date, tells you the place, says that the offender did not follow verbal directions, and that there was an imminent threat of battery. And it says exactly what the member's response was, that he gave verbal commands, that he was present, and that there was a takedown, an emergency cuffing. And if you couple that with the OBR, you know what happened. The OBR says that he was on duty with one partner, and that there were two officers who were battered, as we all discussed, that is apparently interpreted as battered or assaulted, and that there were verbal threats. And then it says, looking down at type of weapon threat, firearm caliber, a 9mm semi-automatic weapon, and it says officer at gunpoint. And that is what the event was that led to this. Nothing checked with regard to battery, nothing checked with regard to assailant deadly force. With regard to the Walsh reports, same thing in essence. Did not follow verbal direction, member present, verbal command, imminent threat of battery, under assault, nothing for battery, nothing for deadly force. And here we have a little bit more, and that is he writes down that the offender stated that he did not mean to point his gun at the officers. So you know, even in the TRR alone, that the offender pointed the gun at the officers. If you look at Walsh OBR 5, you see once again, the officer is held at gunpoint, and that there were two officers, and again, nothing checked on the TRR for imminent use, for uses force likely to cause death or great bodily harm. It is directly responsive. It's not a mini trial. If they wanted the police reports, we can certainly get them police reports concerning these events, but it is their statement, not the police reports, that are relevant. The purpose of these reports are to describe all relevant circumstances of these offenses, and it tells you exactly what happened. Those party admissions are admissible and relevant in this case. There's nothing, by the way, that shows the Walsh training records are in evidence. There is nothing that shows that he had any training between the time of the incident in this case and the incident that is described in this subsequent TRR and OBR. So as far as it being a subsequent remedial remedy, not so. It is that Mr. Walsh knows how to fill out a TRR and OBR, as does Mr. Gaffney, when as appropriate.
Anything further, Mr. Pugh?
Yes, sir. I understand the state's position on our request or your request for relevance to these documents. It is being admitted into evidence or offered into evidence to show that Joe Walsh knows how to fill out a TRR. In order for that to have any meaning, you need to have the facts surrounding the case of which the TRR and OBR were filled out. If you pay attention, despite the fact that when I look at the officer battery report associated with Joseph Walsh for this incident that occurred in 2015, apparently there was a gun pointed at he and another officer. There's no gun listed at all in the type of weapon threat section. So we're left to wonder what that means. If it was a TRR, OBR filled out because the gun was pointed, you would expect, as Mr. Staper represented the Gaffney exhibit, that there'd be a certain type of weapon with a description of that weapon. However, it's blank in this one. We're left to guess what that is. The state's position that they're tendering this the 11th hour in a very incomplete form. And it says, because it's relevant to the, quote, state of mind of Joe Walsh. And it begs the question, when? On October of 2014, is somehow these documents that Joe Walsh submitted in 2015 relevant to his state of mind as it existed on October 20th and 21st of 2014? Because that's the only thing that would be relevant during the course of this trial, even Joe Walsh's state of mind on those days. And I fail to see, I hope the court fails to see how something that somebody did a year later, which based on the exhibits that actually we just admitted into evidence, there's an open FBI, there's an open government investigation, there's a video has been released at least a month later, but this is all going on during this period of time, that perhaps maybe somebody did a better job with their reports a year later in the wake of all of this. And I think most importantly, and maybe this is where the state here kind of misses the point, and maybe I don't because I actually do this all the time, which is that all reports that are submitted in any particular case are always submitted with the understanding that you're to read this report in conjunction with all reports submitted under RD number so-and-so. That is how a case file is tendered in discovery. And that you don't read one report in isolation and feel that this report gives you any particular meaning. But that's what's happened here is that we're going to give two reports from an incident that we don't have any knowledge of, the facts, circumstances, what it was about, other than the checkboxes on here where it says it was a domestic disturbance and the offender was under the influence, and seems to reference that the offender pointed a gun at the two police officers, one of them being Joe Walsh. However, there's no reference to a gun ever being recovered here. That is something that I think court, or at least any finder of facts, would feel would make these make more sense, assuming they're even relevant in the first place, something that Joe Walsh did here afterwards. I guess if these were to be admitted, then maybe we should look at every TRR, OBR that Joe Walsh ever filled out in his career, and we should have all of the reports for all of those if this is the direction the state wants to take at this time. I was unaware that they were ever going to take that direction, and they now want to take the case in this direction, and I don't think it's fair, and I don't think it's complete, and most importantly, the documents themselves have no relevance to these proceedings at all. If it's being offered to show Joe Walsh's state of mind a year earlier, to show what he might have done a year later. So for those reasons, Judge, and it is, at the very least, it is a subsequent remedial measure, and the prosecutor's argument that his personnel file that doesn't show that he actually got training on TRRs in that particular period of time, that's not, it's a bit of a red herring argument as well, because of course, after an incident where a TRR had to be filled out, you've heard the testimony regarding how a supervisor, actually 3 layers according to Sergeant Snelling, they have to accept, send back for changes, reject or accept at that point in time again when it goes to another level. That is certainly a procedure that every officer who is in the field is certainly a training and experience of how to fill these items out. We don't have any evidence in the record as to how many TRRs Joe Walsh was required to fill out in his career. They haven't chosen to put that in. But for those reasons, Judge, we move to object.
Thank you. Anything further, Mr. Fahey?
Judge, I would just add that with regards to the cross of Sergeant Larry Snelling was cross-examined regarding this incident, not some incident 7 years earlier. We never had the opportunity to cross-examine him about an incident that happened 7 years earlier because it's not relevant to the proceedings that are before Your Honor. And with regards to my client, Thomas Gaffney, Sergeant Snelling was cross-examined about what should have been checked off on the TRR report of Officer Gaffney. He said under that fact scenario, absolutely, all the assailant boxes should have been checked. And those were the boxes that were checked by Officer Gaffney as it related to the incident that happened at 40th and Karloff. So now, apparently the state realizing that they can't even show that my client made a mistake in his report, they're going back 7 years and pulling up a TRR that I'm not even sure what the relevance is. If they're trying to suggest that Tom may have checked the wrong box on this one, but not the one in the incident case, that's not relevant, Judge. Judge, we would ask that that evidence be excluded.
Your Honor, just the opportunity.
I don't typically go back and forth, but I'll allow you, Mr. Safer, but then I'm going to give the defense an opportunity to reply because it's their objection.
Thank you, Your Honor.
You're welcome.
I do not want to argue further. I just want to correct two things on the record.
Okay.
One is that all of the OBRs and TRRs, as Mr. Pugh said, that have been completed by these defendants were produced to them on December of 2017. So they had all of these in their possession. Secondly, Mr. Fahey's representation as to Sergeant Snelling's testimony is absolutely wrong. What Sergeant Snelling testified to was that given a hypothetical, he would have filled it out with all those boxes checked, not the circumstance that Officer Gaffney makes.
Thank you for that, Mr. Safer. The court's taking into consideration the objections, the arguments made by both the defense and the state. Your objection is sustained. The court finds that these documents are not relevant. The defense did not open the door to allow this evidence, so those exhibits will not be. Your objection is sustained. We'll just leave it at that.
Thank you, Your Honor. There's only one. I think there's only one more matter that we have before we close our case.
Okay.
And that.
I think that I have several.
Okay.
Go ahead.
The one in addition to the courts that we have is we would move to strike the portion of the cross-examination of Jose Torres where he was accused of violating Judge Gaughan's witness exclusion order. It is our information that there was no such order entered into that case. None has been presented to Your Honor. We have spoken with Mr. McMahon's staff who said there was no witness exclusion order.
Are you saying that Judge Gaughan did not order a motion to exclude witnesses in that case at all?
Exactly, Your Honor. Very unusual, but that's exactly what happened. And I think all parties have reviewed the record, and in fact, the record does not reveal that a witness exclusion order was entered. Typically, first thing that's done at a trial, and that was not done. Mr. McMahon's staff expressly said it was not done, and absent the production of evidence that it was in fact excluded, we move to strike that section of Mr. Torres's cross-examination order. Because it's a bench trial, ask the court to disregard those.
If I remember, I'm just going to look at my notes real quickly here. I think he said he wasn't aware of it.
He did. He said, but the question was, by watching your son's testimony on television, before you testified, you were violating Judge Gaughan's court order regarding the exclusion of witnesses, weren't you? The court should be informed that there was no such court order. And so we would ask the court to disregard that.
That there was a court order?
Yes.
Okay. Any objection or comment on that, Mr. McKay?
Just briefly, and I mean no disrespect to Mr. Safer. But that's the most incredible thing I've ever heard. Over 30 years of trial experience, I make a motion to exclude witnesses in every case, misdemeanor or felony. Every case I ever watched, motion to exclude witnesses done. It was done in this case. And somehow, arguably the biggest case since John Wayne Gacy in this building, and no motion to exclude was made by the parties. I can't believe that. It is so incredible. I can't believe that at all, based on experience and common sense and good trial practice. Now, Mr. Torres can say he wasn't aware of it, and that's the record. That is his answer, and so be it. But I know that.
Not to interrupt you, I really don't need any further argument. I was just giving the parties an opportunity. It really doesn't matter if there was a motion to exclude in that trial or not. The relevant issue is, did the witness believe that he violated the court order in watching the son testify on TV? He wasn't aware of a motion to exclude, and I'll take his testimony for what it is. And it's a bench trial, and the court's only going to consider the evidence that's presented and the relevance of it, and for the purpose that it's testified to or admitted. So, and I am noting what you said, Mr. Safer, and I will give it the appropriate weight.
Thank you.
Okay. Anything further? I have at least three other stipulations up here that are file stamped but not mentioned. One is a stipulation regarding Zachary Barden, or is that a defense? That's a defense. Okay, there's a stipulation. Let me see. Okay, these were previously filed. That's the only one. Right, I guess that was it, Mr. Safer. Anything else?
Judge, we would ask leave of court to provide the court with a full set of exhibits after we've had an opportunity to redact private and personal information that during the course of the trial noted had not been redacted, so that we want to double check and make sure that every exhibit has those birth dates or other personal information redacted. With leave of court to do that and the admission of all of the exhibits and testimony, the state would rest the case.
Okay, I think you've addressed every exhibit you've admitted at a specific time that it was either testified to or in a stipulation. Are there any other exhibits that weren't admitted that you're seeking to admit?
No, Judge.
Okay. The court will accept the redacted exhibits from the state. Are you going to, and I would like for you to give a copy to the defense as well, so they know exactly what the court's receiving.
Yes, Judge, and the defense has used some exhibits during the course of the state's case, and will actually redact those as well if they don't mind, and provide it for them.
Okay. Okay, so then you said with the
and
admission,
then with the admission of the exhibits and all the testimony, state rest.
State rest. Okay. Does everyone need a moment, or are we ready to go forward? Because I'm ready.
Bathroom.
Yeah. All right. The court will be in recess for about 5 or 10 minutes.
Thank you.